So today we are going to be looking at the sentencing and the correctional system of Canada. And arguably, this is one of the biggest topics that we'll have time to cover in this course. And as we begin looking through this, I will just be focusing on the Canadian perspective and the Canadian Criminal Code with various constitutional rights and charter rights that applies to Canadian citizens. It is all right to think that some of these things might be different for you because a lot of shows that you see on television are often telling the criminal code from the American point of view, which is quite noticeably different compared to Canada. So with that installed, let's get started. So the goals for a sentencing is essentially a seven-part goal for it. In no particular order, we'll just start from the top left and work our way around clockwise. You may want to be making pauses at various points in the audio notes to make sure you get this down. So this first one is retribution, the eye for an eye form. And that dates all the way back to Hammurabi's whole stone-clad tablet, the way to punish those for the action that was caused by their previous action that had caused harm. Second goal is deterrence. It is still a form of punishment, but it is not as severe of a punishment compared to the retribution. But the idea of the goal for deterrence is the individual perpetrator, offender, is convicted of it, but are punished just enough so it will motivate them, for lack of better words, that they will never do it again. Third of the goals is rehabilitation. And the idea of rehabilitation is that they can be essentially retaught, rehabilitalized, so they can be released back into the general public. And that is one of the main details or fundamental points that makes the Canadian system different from the American system. The Canadian system tries to where it can to rehab the offender so the offender can go back into the public and be a productive law-abiding citizen, whereas the American system is about punishment mainly. That's why America does have the highest incarceration rate of any industrialized and developed nation. But the idea of a goal of rehabilitation is to bring someone back so they can be a responsible, law-abiding citizen. A fourth goal is recidivism, which is to punish those who are essentially are a repeat offender. They have a criminal code, they have a criminal record, um, they've been arrested by the police on maybe numerous times, or they are known to the police, they've been in trial. Essentially, there is already a record on this individual and that also shows why the criminal record is a very important piece when it comes to the Canadian Criminal Code. Fifth is restitution, a way to pay back to society, or a debt needs to be owed, needs to be paid back to society for an action that has harmed society. Sometimes restitution can be payments or apologies, community service hours, part-time. Now, there's a lot of option when it comes to the restitution for the payback of society. Six is a denunciation, shaming that person. Now, that doesn't happen all that often in Canada, but there are definitely some examples where public shaming does occur. But like I said, that is kind of far and few in between now because of the Charter and various constitutional rights. And then the seventh and final for the goals of sentencing is to protect the public. And going back to the whole policing, especially RCMP with the eight different mandates, the RCMP, one of the main goals they have is to ensure public safety. That's why there is all these different kind of police levels. Now, when it comes to the actual procedures for sentencing, there are different perspectives to bear in mind. And those perspectives are threefold. First, for the perspectives to consider is the offender. Who is this individual? What is known about this individual? And all this background knowledge on this individual is often done by a pre-sentencing report. What's the background? Family, past health. Does it have mental health? Does it have, is he or she in good financial standing? Do they have a criminal record or not? What's their school records? Do they have a license? Do they pay taxes? It's kind of pre-sentence report is just bring all the documents, everything that is known about this individual there to get the clear understanding of it. Plus, sometimes there can be a psychiatric assessment that can be done. In some cases, the individual may want to see if they are criminally not responsible. There was a case in Alberta where the Greyhound bus, the individual was found not criminally responsible after killing the person, beheading, and well, I'll stop there. That was kind of a really gross situation there that happened. But that's an example of not find someone and are not criminally responsible. But that's part of the psychiatric assessment that needs to be done. Another perspective is the victim, and largely the victim impact statement, which in this statement they describe what harm or loss, injuries, how do they feel, what has changed, what has been done to them, how are they for the victim. And then the third and final for perspectives to consider is society. Safety, previous record, time spent being incarcerated, what has been done in society, the collective good, in other words. And during the sentencing procedures, there can and the actual sentencing hearing. So a sentencing hearing happens after the person has been convicted guilty by the jury, and the judge will determine what is an appropriate sentence. There are some aggregating factors and mitigating factors. Some aggregating factors from the sentencing hearing is criminal record, severity, was the convicted's attitude there, what was being said by the victim's impact statements, or mitigating factors such as what are the circumstances, employment, remorse, or how does this, did the accused and convicted show any remorse? Did they apologize, or were they stone cold? Um, there's a lot of that. Actually, going right back to the psychiatric and mental health, mental state is becoming a very more and more increasingly important part of the sentencing and also just the actual trial itself, which is actually a really good industry to get into if you're looking for a job option. When it comes to traditional sentencings, there are quite a few different options, a lot of actually options that they're available to the judge. While a judge will consider the options, there are four questions that a judge usually need to ask. First, can the person be rehabilitated back in society? Will the person be a threat to others? Is restitution warranted? And especially for the Young Offenders, YOA, Young Offenders Act, or Juvenile Delinquents Act, basically teenagers who commit something under the criminal code, if they are sent to prison, could it make it worse? Or will they set free make it worse? So option number one is discharges. Releasing the quote-unquote bad guy for just a minor or a first offense. And if the judge selects a discharge, there are two options. One is absolute discharge, which means the person is released and the criminal record, as long as the conditions are met, the criminal record is destroyed after 1 year. Or there is a conditional discharge where the person is released on conditions such as avoid contact, no booze, no alcohol, no drugs. There might be a probation officer, say no access to internet or phones. So there's a lot can be conditions on it. And then if these conditions are met, then usually after 3 years, the record is destroyed. However, in a conditional discharge, if it is broken, the punishment usually becomes a lot more severe. And the person, basically, a warrant is issued for the person's arrest and to face the judge once again. A second option is probation, which essentially allows the offender to live in the community under the supervision of a probation officer. This usually includes check-in times, maybe like a ankle bracelet, curfew, limited access, no-go zones, probation uh, officers, and they can live into the community as a form of see if the person can be rehabilitated back into society. Number three is suspended sentence. A judge may opt for no sentence provided certain requirements are met. Essentially, you are being convicted, but are being let go for reason. But if those conditions are broken, then the sentencing, which means prison time, incarceration, will occur. Fourth option is intermittent sentence, which can be served on weekends and or at nights. Usually intermittent sentence means a person is sentenced to jail for less than 90 days, and this is usually done for non-violent or job or for family considerations. And when probation, when the person's out of jail. So basically, on say Joe Doe, he is in prison for Friday night, all throughout Saturday, but he's released on Sunday. And during the weekdays, Monday, Tuesday, Wednesday, Thursday, so like Friday morning, Joe Blow is living in the community at like a midway house, and has to be regularly checked in by a probation officer. That is intermittent sentence. Number five is a conditional sentence. And a conditional sentence is prison that can be served in the community. Uh, Usually, a conditional sentencing means there's no minimum sentence. It's usually stricter probation, and conditional sentencing may include having to go to do community service hours and or going to various addictions centers and classes. Number six for options is electronic monitoring, which is sentenced to serve at home while being monitored with an electric ankle bracelet or have breath samples, closed video. Essentially, I guess the way we can look at electronic monitoring is house arrest. There with, and whether the person wants to leave, then there are procedures in place. For number seven is suspension of privileges, such as the suspension of a firearms license, suspension of driving, suspension of our motors, or no, it's a license that has been taken away, and that's the idea. Suspension of privilege, something, so whatever privilege a person had has now been taken away, and suspension of privileges is often now associated with motorized vehicles, whether it's drugs, alcohol, cannabis, etc. Actually, the image in the bottom right corner is what is typically be done for anyone who has suspension conviction of DUI in Ontario. Number eight is a binding over a peace bond, which essentially means good behavior for 12 months. You're on a peace bond order. It is kind of like a restraining order, but it's temporary. It's placed on someone who has issued a threat there. So you basically have been warned to stop. But from the police giving a verbal warning, say like on the phone, that wasn't enough. Whatever, say example, the harassment had continued, the police filed and pressed charges, and the judge may like to have a binding over a peace bond. So then the person essentially is ordered to stop wherever this say defamation or harassment behavior is, and this peace bond will last for like 12, at least 12 months. Still can be more, of course. And if it's broken though, then it turns into a crime, and at that point, since the peace bond has been broken, um, that person would be facing jail time at that point. Number nine is deportation, which is essentially expulsion, expelled from the country, which is an indictable offense of a non-Canadian. The example, Vancouver Chinese street racer faced deportation after killing a pedestrian there. Their deportation does only usually work when um, there's lots of other mitigating factors for it. Actually, deportation can take a long, long time to be processed through the courts. The 10th option is a plea bargain, which is a negotiated deal to essentially a guilty plea to receive a lesser um, sentence, um, or there are fines, which is money that needs to be paid out in a penalty for a crime. So I mentioned this a few times, so it actually makes sense to cover it now. Incarceration. What does incarceration mean? Jail time. Incarceration must be a specified length of time. Maximum for a life sentence is 25 years. No, dangerous offenders can be sentenced to indeterminate sentence, indefinite, basically, indefinite amount of time, which then will change what are the terms for bail or for parole. Concurrent sentence are sentences that are served at the time, or a consecutive sentence is when sentences are served one after the other. Essentially, concurrent can have multiple sentences for multiple convictions on top of each other, but it's all kind of like sandwiched together. But consecutive kind of means one sentence is done, and then the second one begins, and then the third, and then the fourth, the fifth, and however many there is there. And you can see on these images here, I've given some um, uh, examples of both the pros and cons when it comes to jail time. But like I said, one thing between Canada and the United States, America does definitely have a lot more incarceration compared to Canada. There is also the restorative justice programs, which basically are various programs that focuses on using joint problem-solving techniques that can usually involve offenders, victims, community, and the idea of the restorative justice program is to restore, rebuild, reconcile, forgive, and maybe remorse for as part of that rehabilitation program or mantra of the Canadian system there through victim offender mediation or family conferencing, Aboriginal sentencing or Aboriginal healing circles or victim offender panels. Once again, the roles of psychology and getting the community involved. Um, this goes right back to the various things we talked about with the 7 goals of sentencing. There's also the correctional system, which can approach of getting tough and violent or alternatives for low risk. Essentially, the correctional system. Here's some facts. The facts. The toughest and most costly penalty we have is life in prison, as we do not practice capital punishment anymore. But the correctional system in Canada does cost at least $3 billion a year, which on average means and to keep one person individual in jail, like the Prince George Youth Correctional Services, it is $95,000 a year to keep a person in jail, or having someone on parole can be anywhere between $2,000 or $9,000 a year. But we definitely have far fewer amounts of people in the correctional system now. There actually are different types of prisons here. Starting with the provincial, there's a provincial correctional system, and then there's a federal correctional system. When someone is in the provincial correctional system, they are there, whether say like the Prince George Correctional Center or Prince George Community Center for women's side. They are there for give or take under 2 years, and they're there because they are either waiting for the trial to occur, or they're the provincial system awaiting for their sentencing hearing back in court after being convicted. But the first one is for what we see for provincial systems, because there's different types. First one is open custody, which tends to be less secure, often available to those who are viewed as non-violent offenders or someone that is not a flight risk. But they tend to be less open custody tends to be less secure because they will be placed into a halfway house in the community, which is going to be under surveillance. Or a second option is protective custody, which is a separation of the prisoners. And they usually do require protection because they require psychological care for protective custody. Or third is closed custody, which basically means they are dangerous. They are deemed, the person deemed could be a flight risk. Basically, this person needs to be locked away for a while. And so because of that, the closed custody is a secured facility. Once that's done, then you have the federal system. And in the federal system, like the provincial, there are three different levels. And in the federal system, there are used for sentences that are 2 years or more. And so a minimum level security prison has no exterior barriers like walls or towers. The guards usually tend to be unarmed. Those who are put into a minimum security prison can actually have jobs. They might have education programs like a culinary. They are there for uh, only for a short period of time. Or a medium security, which does have some external barriers, fewer guards. But for medium security, though, the prisoners do tend to have more freedom and contact with each other within the boundaries of the facility of that prison. Or there is the maximum security, which is, well, as the name kind of implies, you know, walls, guard towers, bars, razor wire, fences, towers. The guards are armed. Uh, Insert Alcatraz as an example of the maximum security kind of prison. And that's for the worst of the worst, the most dangerous of offenders, those who are sentenced for for lifetime sentencing are sent to the maximum security. Then there is the options, of course, of the jail time, the pros and cons with each. For jail time, there is the correctional programs. Once again, remember, it's all about rehabilitation with a plan, needs, priorities, school, work, the community, etc. But some of the programs can be life skills, literacy, work experience, cognitive skills training, substance abuse programs, sex offender treatments, family violence prevention programs. There's a lot of programs, a lot of classes, a lot of courses, a lot of sort of activities for the person there. And part of the reason why there are these kind of all these programs are there is because the Charter of Rights and Freedoms. Even someone who's in the maximum prison security for a lifetime sentence, because of the Charter of Rights and Freedoms, can still vote. They can never run for office or anything like that, but they can still vote. There are still some basic all the various human rights and some fundamental rights and freedoms that are granted to that individual, even if they are like the Robert Pickton or Clifford Olson, um, to name a couple of the real worst case examples in the Canadian system. Parole, as we mentioned before, is the release of an inmate before the full sentence has been served on the promise of good behavior. Parole must be reviewed after 1/3 of the sentence has been done or 7 years, whichever comes first. The exception is, of course, is where there's been done for first-degree murder there. The National Parole Board will make their decision based upon risk, social issues, behavior, employment advice, and treatments, the offense, mental status, criminal history, family, victim impact statements, chances of success. Uh, we're going to look more into this with the Latimer case there, but on one, this is where the Canadian system gets pretty controversial. Other than the fact it takes a long time to be processed, For the victims, even they still sometimes will need to give impact statements and almost have to relive through the pain that what had been caused before, even after trial has been done there, because under many circumstances, the offender will try to get released from prison earlier, basically seeking earlier parole. So a lot of times the families will have to come back, give their statements over and over and over again. But also, the National Parole Board can also make someone ineligible for parole for dot 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 kind of reason. Because once again, as you're starting to see, as we're working our way through, especially this time with the criminal code, as you're seeing, it takes a long time to get things done. And it's kind of like the Canadian government that way. Things are designed to be slow, methodical, and not rushed. There are releases, so different kinds of releases from conditional release, unescorted temporary absence, day parole, full parole, statutory release, on conditions. These are the type of one of these kind of conditions for release when prison is going to be made available to those who qualify or who have served their time and paid their debt back to society. And then last but not least are pardons, which is the setting aside of a person's conviction. Charges can be filed away, can only be released by the Solicitor General. However, foreign countries may now recognize a pardon. One thing, example of the pardon has come up quite a bit is for those who got in trouble with possession of cannabis in Canada. Um, and they try to cross over into America or vice versa. And that is the sentencing and correctional.